officially summer until fall arrives a week from tomorrow, and it'll be kind of feeling like it, mostly in the 90s for highs, but mornings stay comfortable in the 60s.
Good morning temperatures and great sunshine. Thanks for watching WAAY 31 News at 10. Stay right where you are. WAAY 31 Law Call is next.
This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight it's Ask Us Anything night, so call in your questions on any legal topic. Maybe you've been involved in a car accident. Maybe you've got a family member that's been injured at a nursing home facility. Call in and you can ask us things live on the air. Be live with us tonight, 256-536-0077. You can call in and be live. You could also text us to that same number and ask your questions. You can also email in questions on any legal topic any day of the week. You send it to lawcall@waytv.com. And when we get to a show that's on point, we pull some out. We will have some of your email questions tonight. We've got William Messervy with us tonight from Timberlake League and Brooks. Good to have you with us.
Glad to be here tonight.
So we're going to be talking, it's Ask Us Anything night. Personal injury cases are what your firm does. So what all does that entail?
It can be anything from, like you said, an auto accident, something that occurred at a nursing home or assisted living facility. It could be someone who's injured on the job. It could be what we call premises liability, sometimes referred to as a slip and fall, getting injured on someone else's property. It could be a fire. It could be any number of things. So, you know, there's unfortunately no end to the way in which people get injured.
People hurt one another in all kinds of ways.
And, you know, if it's someone else's fault and, you know, they've insured themselves for that purpose, just in case they cause injury to somebody, you know, typically there's a claim to be made.
And I do family law, so we'll be handling all kinds of questions and looking to see what comes in. We like to get you started with some video, and this falls right into your area. So we've got some video tonight. This what comes in from our sister law call station around Mobile. So imagine this, you're driving around a lonely country road and you expect to maybe see a deer on the road, maybe bear in North Alabama. How about this guy driving on the wrong side of the road? So if you didn't have this camera in the vehicle, I think it would be very easy for this driver that's on the wrong side to say, no, it was you. You were driving on the wrong side of the road. So thank goodness he had a vehicle. This was actually in an 18-wheeler. The camera is rolling in an 18-wheeler. Both parties had injuries, and we understand the driver that's at fault here was maybe had some alcohol.
Yeah.
When you're looking at something like this, does it surprise you that an 18-wheeler would have a camera installed? No,
we're seeing dash cams more and more in commercial vehicles, and honestly, I wish we were seeing them more and more in private use vehicles. You know, I've had several clients, and it just happens more as technology advances, but you know, that have these personal dash cam devices.
Yeah.
Just plug it in their dash and record while they're driving. And, you know, it keeps the other party from being able to say, hey, this happened or that happened. A lot of these record speed as well.
Right.
And so, you know, it just puts all the data in your hands, because Alabama is different from most states. In most states, if you were partially at fault, you could still recover the majority of the damages.
Yeah.
But in Alabama, if you're 1% at fault, you're barred from recovery against the other party. So they don't even have to make the collision your fault. They just have to make it a sliver your fault.
If you're driving a little too fast, maybe, or something.
And so like you said, you know, maybe the pickup truck in this video says, well, you know, the 18-wheeler was in my lane. Yeah. And that's where the impact occurred. And, you know, that's where the evidence of the collision is going to be for the state trooper that arrives. You know, but then the law enforcement officer is hopefully going to, you know, detect the smell of alcohol in the pickup driver's breath or within the cab of his vehicle or whatever it may be. But that video is a little harrowing because it looks like any rural road in North Alabama
it does.
At night. And so, you know, it's unfortunately something that we see in our office quite often.
Okay, are you starting to see more of the little gadgets, like insurance companies? Some are wanting you to have an app and maybe a little thing mounted in your car with the idea that if you've got a good record, this helps back up that you're driving safely and it will keep your rates low.
Yeah, and
are you seeing that as evidence?
We are seeing that more, and it does things, you know, like monitor how often you're using the vehicle.
Okay, yeah.
It's recording speed. It's you know, recording what trip you took, sort of like GPS. but we are seeing more and more of that. And sometimes that's going to work to a person's benefit.
Okay.
And sometimes, if they have a tendency to have a little bit of a lead foot, it could cut against them as well.
Okay.
But I was meeting with somebody last week who had been, rear-ended by a big truck. And they had, this app. And, they were able to screenshot it, that they were going the speed limit, that they were doing what they were supposed to be doing. And so it does come into play. And as long as you are obeying the law, I think is probably a useful tool.
Could your insurance company not cover you if they see that you had this accident and you're speeding?
Well,
or do they have to cover you?
Well, it goes back to what we were just talking about as to who's at fault.
Okay.
Right? And so if the other person's making a claim against you and you're telling your insurance company, hey, look, the speed limit is 45 miles per hour. I know it's going 45 miles per hour. But you're using this app that they have access to.
That says otherwise.
That says you were going 57 at the time of the collision. And they're probably going to pay that claim for the other driver, assuming that then shifted the responsibility to you.
Maybe jack up your rates in the future. Maybe.
Good.
Okay, we got this email question in. We got this in from Charla. Charla says, I was hit by an 18-wheeler truck while sitting at a light, and he was making a really wide turn. Am I to blame for not giving him enough room? His insurance guy's actually trying to tell me that.
I'm going to say no.
Okay, good.
All right. And, there is a line at intersections you're supposed to stop behind.
Yeah.
But let's even assume that, you were up on the line.
Okay.
And you're at a stop, at a complete standstill. I mean, the truck is going to see that before he begins entering the intersection. So there are some pretty specific rules for 18-wheelers on where they're allowed to access the road from. They're supposed to access the road from an intersection that gives them a wide enough berth.
Yeah.
Now we know that that's not always going to be the case. But, you don't have a duty to slam your car in reverse if a big truck's making a turn, because you could,
hit somebody behind you,
the
right?
person behind you, or cause a chain reaction where everybody's putting it in reverse. And
So Charlotte, don't take that. Don't take that from the insurance company. They'll try to talk you into anything, right?
I had a client that I met with a few weeks ago that, liability was as clear as day. Someone pulled out on a red light in an intersection. There's two witnesses saying that the other driver had a red light.
Yeah.
And the insurance company tried to tell my client that he was 25% at fault for not keeping a proper lookout as he was traveling through the intersection. So, insurance companies sometimes say things that aren't always right, and that's, why we remain employed.
Go run it past a lawyer and be sure that that they're giving you the straight before you take some answer from the insurance company. We've got Robert on the line with a question from Huntsville. Hi, Robert. Thanks for calling. What's your question tonight?
Yes, ma'am. Hey, Sharon, how you doing?
Hi, good to have you on.
Okay, listen, I'm asking about the situation in Arkansas. I thought you had an accident here. Situation. Who's liable? I know the police have immunity.
I'm not getting much of that. Are you getting much of that?
I know the police.
Law enforcement chases people.
When law enforcement, we've had a case story recently in the news about law enforcement chasing at high speeds, right?
We did.
Are they allowed to do that? What's the limit?
So, law enforcement officers have state agent immunity if they are responding to a call. Okay? And so, if the lights are on and the sirens are engaged, then, they're typically going to be exempt. They're going to be immune, okay? Unless they were reckless or wanton, which is a question for a jury. So it can be very, very difficult to make a recovery in that situation. Now, let's say, and we've recovered against law enforcement officers before for simple errors they make while driving. As you can imagine, 98% of the driving that a law enforcement officer does is not in response to an emergency call.
Right.
And so, if he runs a red light and hits somebody just in the course of driving and while he's on the job, then there can be recourse for that. Okay. But in those situations where They're legitimately responding to a call. Lights are on, sirens are engaged, and they're doing everything that they're supposed to do. They can enjoy state agent immunity, where you can't go after them. And it's a tricky situation because the insurance companies have argued that your uninsured motorist coverage does not apply in that scenario either.
Oh, really?
Because it is not an uninsured vehicle that hits you. It is, and it's not an underinsured vehicle that hits you.
Right.
It is an insured vehicle that is enjoying immunity at the time of the collision. So very tricky cases, but it is typically going to be a question of fact for the jury as to whether or not, the officer was reckless and wanton, or if he was, and if so, there could be a recovery, but negligence or anything else is going to fall under the immunity category.
Okay. We had a question calling in, talking about immunity kind of things. Somebody had texted in asking if my child slips like in water at school and they have to get stitches, is the school responsible? You leave your child with the school and you expect them to be taken care of. If they get injured while they're there, is the school responsible?
If it's a public school, they are going to likewise typically be immune unless their conduct was reckless or wanton. But simple negligence, failure to clean up a spill, or failure to warn against it, probably not actionable. A private school is a little different. They don't enjoy that immunity. And so, they'll try to make you sign a waiver or different things, but private schools can be held responsible. Daycares, nurseries, all of those types of things. We've handled situations against those types of folks before.
Okay. We're going to take a break. We'll be right back. If you're on the line, stay on the line. I'm also going to ask you some more about waivers and kids, because lots of places you go, parks that you go to, water parks, theme parks, they want you to sign a waiver for your children. Can you waive your child's right to sue if something happens to them? So we'll talk about that when we get back. We're live. Call in and be live on the air with us.
Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Messervy. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back. It's Ask Us Anything night, and William Messervy is here from Timberlake, League & Brooks. you may be surprised, or you may know from watching this show enough times, the guys at Timberlake League and Brooks are always involved in community activities and have kids activities. And we have something we wanted to show you that William was involved in. When was this?
This was last Sunday.
What is this? What are you doing?
This is the Rain Gutter Regatta for Pack 361, Cub Scout Pack 361, where the kids build these little boats and then we race them down these lanes of water to see who wins.
Very cool.
Yeah. So we had a big time.
That looks like fun. I've been to a party one time that it was a long time ago, not PC, but we were racing goldfish in something very similar. They took gutters off a house and closed up the ends, and we're having goldfish races. That's a long time ago. We've got callers waiting, and it's Ask Us Anything night. So we've got Howie on the line with a question from Huntsville. Hi, Howie. Thanks for calling. What's your question tonight?
Yeah, hi. I inherited an undivided half interest in a house about 25 years ago, along with a relative of mine, and we took the deed and recorded probate records and had the house tax assessed in both our names, and we both been paying the taxes. But at the beginning, I allowed I gave permission to my relative to move on in, and I told him that eventually I was going to want to have a sale for division eventually when I needed the money. And it's been about 25 years, and I told him that I want to get move for a sale for division, and he told me that I couldn't do that anymore because Alabama had some kind of 20-year rule of repose. You couldn't file claims after 20 years, and I want to find out if that's true.
That's a good question, and probably one I would run by someone who specializes in real estate law. Typically following, like he said, where you inherit property, right, with a relative.
Yeah.
Any of those relatives can choose to buy out the other relative. And if that's not successful, they can go to the court and say, we would like to move for the sale of this home or of this property or whatever it is, whether the other party wants to or not.
Yeah.
And, the court's going to look at that and in all likelihood move forward with it. Now, there may be some statutes in play here. And, as to whether or not that comes into play, I would run that past, someone else. But typically, you're going to be able to, force a sale of real estate or a property, even if the other party doesn't want to.
We've got Remy on the line with a question from Florence. Hi, Remy. Thanks for calling. What's your question tonight?
Hi, Sharon. Hi, William.
Hi. Hope you're having a good night tonight.
Yes, you too, I hope. My daughter lives in Colorado, and I noticed it first out there, and then I just got back from my home state of Florida, and they're doing it down there, and that is where you would normally have toll booths set up. They just have this, you either have the Sun Pass, or in Colorado, the pass out there, or it goes off of your license tag, and they charge you for the toll, and then they charge you a processing fee and all this other stuff.
Yeah.
And I'm like, do you have to pay that process? I mean, it's the state is too lazy or cheap to put an attendant in there so you can get change. So they just take advantage of you. And I want to know if you have to pay all those extra charges.
I think Atlanta's got some of these now too. We were driving through there this weekend, and I think there's something like the Peach Pass or something, the same kind of thing.
So, for example, in Huntsville could not just decide one day, hey, we want to do this, and so we're going to just arbitrarily set it up and do it, right? But, if the right laws are passed at the state, county, and municipal level, then, the state can do that. Now, there have been some interesting ways in which states have gone about it, to include New York. And, there is some litigation going on in the courts about some of those very issues you're asking about. Where does the line stop as far as these processing fees are concerned? And so the answer is, in some regard, to be determined as to what those courts decide in those individual cases and how that proceeds. But it can be very confusing, and particularly, from my experience with them, sometimes there's one of those toll booths about every mile or two, it seems like. And do you have to stop at just the first one or every one, or, and from my experience, you do get something in the mail when you don't. And so, but as far as processing fees are concerned, There have been some rules in place for those. Some of them have been rolled back, and now they're being challenged in court. So we'll see.
All right. I had promised that I was going to ask you about signing waivers and kids. If I sign a waiver, like at a trampoline park or a water park, saying my children can't sue, can my children really not sue if they get injured by something that's done at that park?
Your children can absolutely sue.
Okay.
But you cannot sue.
Okay.
For yourself.
All right.
Okay. So if an adult signs a waiver, and in Alabama, to be considered an adult, that's someone of the age of 19 years of age, right? So if you're 19 years of age and you sign a waiver saying, hey, I'm going to jump off this bridge with this bungee cord attached to me, and if something happens to me, even if it's the fault of, the employee tying the knot wrong, I'm assuming the risk, and I won't be able to sue if something does happen. That is enforceable because you are of age, as the state views it, to enter into that agreement. But you cannot enter into that agreement on your children's behalf. So businesses know this. Businesses do it anyway because it's a strong deterrent, right?
If you think you can't sue,
you go to them and you say, hey, look, you said that the lifeguard's going to be watching my kid, or this, that, or the other, and, they got hurt. They're going to say, well, you signed this waiver here, and, but they're not enforceable in court, not for children.
If you believe it, they've won, right?
That's right.
We've got Earlene on the line with a question from Rainsville. Hi, Earlene. Thanks for calling in. What's your question tonight?
Okay, I had put my car in the shop. I had bought it brand new back in 2006, and I had put it in the shop, and they changed the oil and the brake sticks, and they found out the thermostat was sticking, so they fixed that, and they charged me $1,900 and something. And it hadn't run a lick since, and they kept it for about a week and a half, and I think they changed the motor out.
Wow. Okay. And it's not running. Not running.
It's not running. And now the wipers, it runs the battery. It'll crank, but you'll have to boost it off.
Wow.
And when you cut it off, it won't crank again. And the wipers, the inside lights is coming on, and the wipers are coming on and staying on. It runs the battery down. I've done changed the battery twice, and it just keeps running it down.
Was it running when you took it in?
Oh yeah.
Yeah. Okay.
So this actually happens more often today than I think it used to, because cars today have so many electrical parts and computers and all these things, and sometimes they go in and they fix something, but then they don't hook the wiring back right, and you get all these other types of problems. If I were in your shoes, my first stop would be at another shop, probably specializing in the computers and electrical parts of a car, and just making sure everything's hooked up correctly. And it may be a simple fix, but if not, you may have a claim back against the original shop. Okay. If they messed up your car in a way it wasn't messed up before. Now the hard part is suing them over it, right? And that's assuming that that she brought the car in here recently, right? I know she said she bought it in 2006, I think. Right. But if she took it in one condition and got it back in a different condition, that can cause a problem. So, but the hard part is if your car's 20 years old, proving the condition that you brought it in.
True.
So it can be tricky.
Okay. Robert's on the line with a question from I think it's from Huntsville. Hi, Robert. Oh, you're back. Yes, you were from Huntsville with part 2.
Hey, you did, Miss Doviet. I called out earlier. The question is, and if somebody gets an accident in my car and I don't report it stolen, am I liable?
If someone is driving your car,
my car is stolen.
Your car is stolen,
and it gets an accident.
Okay.
Am I liable?
If his car is stolen, somebody else is driving and has an accident, is he in trouble for that?
No.
Okay. Good.
No, but we have seen in several instances where people say their car was stolen, right?
Right.
But they never reported it to the police
until the accident.
Right, and so It can be tricky in those scenarios, but assuming that your car was stolen, you reported it as stolen, and then an accident occurs, that's not going to be your responsibility.
Okay, we're going to take a break. Be right back. It's Ask Us Anything night. To get in touch with William Messervy with Timberlake, League and Brooks, 256-536-0770 or 800-804-2502. They do personal injury cases, so that's everything from car accidents to medical malpractice. Check out the website law-injury.com.
And Sharon Doviet, handling all matters family law, adoption, divorces, 256-539-7337, and you can learn more about her at www.sharonfamilylaw.com.
Thanks for all your questions, and we'll see you next week.
Have a great night.